So we'll crack on. I'm not going to, as I say, I'm not going to give any interesting. I've got some information about. There's no embarrassing things to say about any of the speakers who I'm going to mention. We do have some of the people here who are speaking. So just sort of in order. David, lovely to see you from Building Magazine. Gordon Nardell. Roger, I can see you're here. Roger Dahar, QC. Begum, see you. Len from sunny Scotland, can see you. You can also, Donald, hello. And I don't think there's any of the other speakers here. Chris Baris, it was 3 a.m. in the morning for him. I think it was just too much. He was working till late, so he hasn't come. Anyway, we will crack on. So, if you can all please mute yourselves if you're not already muted. Move the slides across. So, can we have the next slide, please? Right, so these are all the different people who are represented. Oh, hello, Karen, as well. Karen Goff is here. Karen, right, okay. Sorry, I'm distracted. So we've got a range of speakers, and this follows on from last year. Obviously, there's far more people on holiday at the moment. I can't believe how many out of office messages I get. It's worse than the opposite of a pandemic, I think. But the aim of this was asking you, the audience, the experts, to think of a question that you think other people would find interesting and to provide the answer. And don't think this is just so it is easier for me, because I have had to prepare some questions just in case. But we do have 20 questions from 19 different speakers today. They'll all be available tomorrow, so don't worry about note taking or all the rest. Everybody will get an email link tomorrow to enable you to download the presentation. You'll be able to download the video as well. So everything will be available through that. And also you'll be able to go onto our website where this webinar and all our previous ones are available. So with no more to do, can we have the next slide, Catherine? So the first on is Bill Howard. I'm not going to read everybody's sort of intro blog because it will take ages, because everybody has so many qualifications. Obviously, Bill spoke early in the year. He's president of FIDIC. He's got huge amounts of experience as an engineer. And if we have the next slide. So as you can see, his question is, what advice would you offer owners in initiating a project, especially a complex one? And his answer is, I'm going to summarize it rather than just reading it. Use your professional engineer. So you employ an engineer, so use somebody at all phases. The procurement process. So in these large projects, there is a set out and a defined procurement process that you need to follow, and you need to set out clearly and agree. Use the appropriate form of FIDIC. So as I mentioned before, when I was talking about NEC, but FIDIC has been updated recently. If you're not sure, go and ask somebody which FIDIC version to use. And then I know something that Donald is also very keen on, chastised me the other day, I think would be the word, is the golden principles. Follow the golden principles of FIDIC. So those golden principles are, firstly, the duties, rights, obligations, roles and responsibilities of all the contract participants must be generally as implied in the general conditions and appropriate to the requirements of the project. The second one is the particular conditions must be drafted clearly and unambiguously. The third golden principle is the particular conditions must not change the balance of risk-reward allocation provided for in the general conditions. Next, all time periods specified in the contract for contract participants to perform their obligations must be of a reasonable duration. And finally, the last golden principle, unless there is a conflict with the governing law of the contract, all formal disputes must be referred to a dispute avoidance adjudication board for a provisionally binding decision as a condition precedent to arbitration. And actually that's a theme that you'll see in some of the other speakers' questions and answers about trying to resolve matters before you are locked into a long-running and expensive arbitration litigation. And as it says here, the fifth one, pre-qualify key project participants wherever possible. And by pre-qualification, Bill is talking about make sure they can actually do the work that they are professing to be able to do. So you have, I think nowadays, to carry out research, and there's also elements there I would flag up to you in relation to fraud and money laundering and things like that. There is a greater obligation on owners, promoters, employers of projects to carry out due diligence on the contractor or contractors that you are using, the consultants, particularly where you're in a multinational, multi-party position. Can I have the next slide, please? I don't think Andrew is with us. No, okay. Because if he was, he'd shout up or something. So Andrew is a QC, but now specialises particularly in mediation. He's a very, very good mediator. I've been fortunate enough, he's had a couple of disputes where he's been appointed mediator. I'd say he's very proactive and exemplifies why mediation is a really good approach. So Andrew's question is, are construction disputes really suited for mediation, and when is the best time to go to mediation? So he says construction disputes and mediation have a major component in common, namely, oh, Bill, sorry, you just missed your questions, but I'll come back to you at the end and you can say a few things, namely negotiation. So negotiation is at the heart of all construction disputes, pre-contract and post-contract, points I've just made. At the pre-contract stage, the parties are looking for the best deal, and at the post-contract stage, parties are looking to move forward in the most economically and efficient way. Mediation provides this combination of efficiency and economy as a process and allows for the final resolution of a dispute. It is not only cheaper than adjudication, but it is also quicker and allows for a flexibility that the rigidity of adjudication can't ever achieve. There is no right time to go to mediation, but as a general rule, the sooner the better. And yes, the mediation can be used as an alternative to adjudication, or may even be introduced as part of the adjudication process. The mechanism for providing a resolution to a dispute in a short time is something that should not be overlooked. At a recent successful mediation, post-settlement, the commercial and financial director turned to their contracts director and said, "Why have you never mentioned or tried mediation before?" Next slide, please. So there you have Andrew's question in full. I would fully endorse mediation. If you don't include mediation in a substantial contract, I think you're foolish. I think if you miss the opportunity to mediate, that is also foolish. And I would encourage as many of you as possible, and it's relatively easy, to undergo mediation training, because it does help you understand the process, and it will help you then explain to your client, or perhaps if you are a client, there's nothing to stop you having mediation training, but it will really give you an additional information and power should that situation arise. And of course, mediation is merely a form of negotiation in an organised way. Any mediation training would help you in your sort of day-to-day life. Next slide, please. Adrian Cole, I don't think Adrian's with us. So Adrian is now sitting as an arbitrator. He's previously was at King's Spalding for a long time. And his question is a contractor entitled to compensation for encountering unforeseen ground conditions? And of course, in true lawyer-like way, Adrian says, yes, no, maybe. So the point he's making is construction contracts identify the scope and the duration and the price to be paid. And so in the absence of anything else, the contractor bears all the risks and burdens of doing that work so described. So under English law, an employer doesn't impliedly warrant that the works undertaken are possible. The employer is entitled to rely on the contract and the expertise of the contractor to carry out that work, and the contractor will not be entitled to compensation just because the conditions are more onerous. So one of the things there is, if you're a contractor or acting for them, why aren't you undertaking more investigations, and why don't you ask for more information? I see this all the time. I say to clients, do you know what it is? And I blank looks. And equally, as an employer, bluntly, okay, you can admonish me all later. I don't think you should set out to screw contractors. I think you should be more open and have a more collaborative way. What is the point of hiding information in relation to ground conditions? Because you think the contractor's got that obligation. All that will happen is your contract will be late, you'll have a claim, and you'll spend 10 times as much in litigation than you would if you just been open and shared that information in the first place. So some contracts do seek to share the risks of unforeseen ground conditions. So for example, FIDIC, clause 4.12, entitles a contractor to claim an extension of time for delay to completion of costs for adverse conditions that were not reasonably foreseeable by an experienced contractor, subject to giving appropriate notices and other criteria. And there is a raft of English case law. And of course, as lawyers, we think that's not quite hard enough. So we will change that wording probably to say of a reasonably experienced contractor or a reasonably experienced contractor carrying out work of a similar scope, nature, size, location, complexity, geographical location as the contractor. So we make the relevance of the contractor far more specific. Therefore, it's much harder for the contractor to show that they shouldn't have foreseen. And then you look at reasonably foreseeable. Well, that again is a hostage to fortune. So it's not always, if that is in your contract, a slam dunk that you will get an extension of time. Next slide, please. And Adrian continues, in Obscan and Lane, the Court of Appeal rejected the contractor's claim where the ground conditions were not expressly identified in the geotech information, with the court holding that an experienced contractor at tender stage would not simply limit itself to an analysis of the geotech information contained in pre-site investigation report and sampling. Well, the court says that, but I'm willing to bet that lots of us on this webinar have seen exactly that happening, and that's exactly what does happen. So in the next case, the court held the contractor failed to prove that subsurface conditions were different from those described or were unforeseeable. So compensation can depend upon proving foreseeability, and that extends beyond the boundaries of the contract document. So once again, one of the outcomes of this is, if you're thinking about ground conditions, look at the wording, and does it include foreseeability? Does it include reasonable? And what do those mean? And have you actually asked somebody to help you interpret those? Can I have next slide, please? Next, Dave Rogers from Building Magazine. Great to have you on board, Dave. Hope you enjoy it. So David's question is, there's a well-known and widespread material shortage. Are contractors liable for materials not turning up, and what can be done? Well, Liability for material shortage will depend upon the terms of the contract and the circumstances. Some contracts specifically allocate the risk of material shortage, so it might be a relevant event or a compensation event. So under JCT, on receiving notice of a relevant event, the employer may award the contractor an extension of time, so relieving them of delay damages. However, contractors are not entitled to claim for loss and expense as a result, so they get time but not money. An irrelevant event is an event not caused by either party. NEC, the equivalent of compensation events, that's clause 60, and they again may entitle the contractor to an extension of time or money. And then of course you have force majeure, so events that relevant compensation events. So that's a question then of, can the contractor show that the material shortage was, for example, a direct result of COVID or Brexit? They might be able to get it within force majeure. However, as we've said to a number of people, if the contract was entered into after the pandemic ongoing of COVID-19 or Brexit, then can you still say that those were not reasonably foreseeable? And materials particularly, we come on in a later question, there are ongoing issues with materials. So for example, I do reference it, British Steel closed the ability to order back in April. Well, if you had steel and you're a specialist contractor, you'd be expected to know that and therefore be well aware of shortages existing and the ongoing problems. Next, because Gordon is here, I'm going to introduce Gordon, and then Gordon can give his answer. So I won't read his question. If you leave it on this slide, Catherine, and then so Gordon, wonderful QC, known for a long time, now at 20 Essex. So Gordon, would you like to tell people your question and answer?
Colleagues, fellow travellers, sometime collaborators on the meeting. Two apologies first of all. I'm actually having some contractors in myself. No force majeure here, though. There might be some background noise from drilling and so on, so apologies for that. The other apology is the day job's about to call. I'm in court tomorrow, so I'm going to have to bunk off shortly after this contribution. I'll just stay on after I've made the contribution just to see whether there are any questions or comments on the chat. So apologies for that. So implied terms and duties of good faith in construction contracts. I think those are on the next slide. If we could bring that up. So when does English law imply a duty of good faith into a project contract? Well, in the classic construction contract situation, good faith has very little to say about anything. The interests of the parties, contractor, employer, subcontractor, are sharply divergent, and the default position is that once you construe the contract and a party is entitled to exercise rights or a party owes obligations, the court won't inquire into the reasons for which a party makes a particular decision or exercises its contractual rights in a particular way. That the default rule is that a party, whether it's an employer or a contractor, can exercise the rights it's given under the contract for any reason, good or bad, or none. So when does the common law, despite its reluctance, imply a duty of good faith? Well, there's been a category of contracts that the courts have started to recognise over the years, which they've called relational contracts, where it's not just a case of contracting with somebody for a specific short-term purpose, such as an individual construction project, but there's something else, some ongoing relationship between the parties from which the courts will imply there's some sort of duty to cooperate, some duty to treat each other with good faith, and occasionally to subordinate your own commercial interests for the common objective of the project. So that's of particular interest in the construction context when it comes to termination. In the construction context, the courts are most likely to get interested in implied duties of good faith, where you're doing something more than simply putting up a building, where there's some ongoing relationship between the parties. So typically a design, build, operate scheme, a contract that's going to last for many years beyond the execution of the the construction works themselves. So what have the courts done with this? In what circumstances are these issues of interest? Well, of course, the biggie is termination. We're all familiar with bespoke termination provisions where parties have a right, an employer has a right to terminate for contractor default. And in the Compass Group case, the court drew a distinction between a situation where a contractual right is absolute, in other words, where the contract itself specifies what is to happen when the right to termination arises, and a situation where there's some scope for the exercise of discretion, some subjective assessment that the employer has to make. And where the employer has to make a subjective assessment, the court will more readily imply a duty of good faith. Now, the final word on this is a rather interesting, more recent decision earlier this year in Dwyer Franchising and Fred Bar Limited. This was a franchise agreement where Fred Bar was a plumber, had his own small business, his own van and ladder and toolkit and so on. The Mr. Bartlett, who ran Fred Bartlett, he was advised to self-isolate when the COVID pandemic struck in order to shield his young son. And therefore, he wasn't able to work for the franchisor Dwyer. He notified Dwyer of that fact and said, "Will you please, franchisor, declare a force majeure event under clause 30 of the franchise agreement?" And Dwyer said, "No, we won't. We're treating your inability to work as a repudiatory breach. And moreover, because it's a repudiatory breach, we're going to seek an injunction preventing you from doing any other plumbing work under your own name." And the Chancery Division said, well, in that situation, we will readily imply a duty of good faith. You've got to exercise your discretion reasonably and not capriciously or for an improper purpose. And therefore, this exercise of discretion on these facts was completely arbitrary and capricious, and therefore the contract hadn't been terminated by a repudiatory breach. So in what situations will the court imply a duty of good faith in declaring a force majeure event? Well, not altogether clear, but the facts of this case were stark. I've given you a short summary, and I think most people would stand back and say, goodness me, that really would be unfair, and the court will be tempted to intervene in that situation. Again, it was a franchise agreement, so something capable of enduring for some time. But it seems to me that there is at least some prospect of the courts recognising this category of discretion, whether to declare a force majeure event or not, that might operate in circumstances other than relational contracts. So ordinary ODIC or NEC or JCT contracts where there's a discretion to declare a force majeure event, the safest assumption is the court may very well find that as an implied term that discretion whether to declare force majeure has to be exercised in good faith. So if in doubt, lay an audit trail. If you're going to exercise a discretion not to declare a force majeure event, record in correspondence your reasons so that if the issue is arbitrated or litigated and the court does imply a duty of good faith, you can demonstrate that there were good commercial reasons for doing so, and the court will be less tempted to say, well, you've acted arbitrarily or capriciously. So that's my contribution. I hope that's helpful.
Thanks very much, Gordon. And I would echo the advice at the end there to evidence what you're doing during the course of the contract with giving notices and a document trail. Document trail for anything under the contract is very important. If anyone's got any questions to the particular presenters, then do put them in the chat and we'll collect them up as quickly as possible, particularly as Gordon has to go. The next speaker is Martin Booker from Fibre Architects. Now, I know Martin is also on. So Martin, do you want to give your question? Are you there, or have you left? Or have you just logged in, but you weren't really expecting anyone to say your name, and so you're not here? Have the next slide, please, Catherine.
So I am.
Oh, there he is. I did see you before. So there you go. So Martin is Managing Director of Fibre Architects, building and design. They do a lot of high quality residential projects all across Northern England. And so Martin, your question is, next slide, please.
Yeah, mine was, can defective construction work or materials on site or any other work or materials not in accordance with the contract during the spec be accepted rather than condemned and asked to be removed, remedied or replaced? Just on the point that This happens quite a lot, and clients a lot of the time just say, well, I want it to be right. But yeah, the answer being yes, and an appropriate deduction being made from the contract sum, I believe. But that's not always as easy as that, because obviously you've got to make sure that any defective work still complies with other legislation, obviously the planning approval, any planning conditions, building regulations, employers' requirements, brief specification, BREEAM if you're working to any environmental standards, relevant British standards, codes of practice, and of course CDM regulations. Now, yeah, I think when I submitted the question, I said, I think the difficult thing a lot of the time is then agreeing an appropriate deduction, because sometimes that's very difficult to quantify for defective or work that's outside the contract. So work hard with your quantity surveyor to to come up with a suitable suggestion.
Okay, sorry, I muted myself, but of course you're all muted and you can't be unmuted unless Rachel lets you. So thanks, Martin, and say there that again, it's about planning. If you need to change the materials, and again this comes up in the questions, then you need to think about the impact on the project, and you need to think about the list of issues that Martin has raised here, because it isn't as simple as just replacing one material with another. And it doesn't matter whether you're building a house or a factory or a power station. You can't just suddenly replace one item. You need to think of the impact all the way through, compliance with specification and all that. And that, again, requires you to engage with the other parties. Brilliant. Thanks very much, Martin. Really appreciate it. Begum, yeah, you're there. So I work very closely with Begum, based in Turkey, and Begum also not only has her own law consultancy practice, but also runs an international consultancy practice called Quanak that has members from across the globe, which is an incredibly diverse and dynamic organisation. So, Begum, would you like to?
Yes, I'm here, and thank you for inviting me to this webinar. And I'm so happy to work with you in every case with Quanak and also our law firm. And before starting my speech, I would like to briefly explain this subject with its general features. So I think we should start from the question. Is it possible to finance an international investment arbitration expenses by a third party? And in this case, what is the legal statute of the third party? Yeah, I would like to start my speech with general conditions. As you know, third-party financing in arbitration can generally be defined as a non-partisan supporting the arbitration costs. The third party can be any natural person or company or legal institute. So what forms of financing are possible? A certain percentage of the price to be awarded in the arbitral award, or a mixed agreement where both forms are intertwined, or a fixed figure without mentioning the price to be awarded in the arbitral award. So arbitration costs can be impossible in some cases, you know, especially for companies engaged in construction activities in the international area. For example, the applicant company may have fallen into insolvency difficulties and maybe even come to the stage of bankruptcy due to the dispute. And sometimes, in addition to the costs of arbitration, the enforcement risk in the legislation of the place of arbitration or host state may create a reluctance to bear the costs of arbitration. Because of these kind of reasons, third-party funding is becoming so important in arbitration process. As we know, it is very important for arbitrators to be impartial and independent. However, before or during the arbitration, the financial provider examines the dispute that is the subject of the arbitration and makes a decision on whether to provide financial support. Refusing or accepting financing by the finance provider may put the arbitrators in a difficult position in a pending arbitration case, as you know. Or any of the arbitrators may be acting as an attorney in another arbitration case of a third-party financier. So, therefore, it is important that the identity of the third-party finance provider is disclosed from the first start, and that the independence and impartiality of the arbitrators are ensured in the arbitration process. As you know, the conflict of interest guide published by the International Bar Association, it was revised in 2014. Yes, I'm right. In the revised text, the financiers were also counted as one with the parties, and the necessity of their disclosure was emphasized on the 6th clause. So, on the other hand, for example, the United Kingdom Association of Dispute Financiers tells financiers to comply with the conduct that the lawyer must refrain from within the framework of a professional code. So, what rights does the financier who is subject to restrictions, such as the party to the dispute, and who is not the direct party to the dispute have? Will it be able to directly carry out the enforcement process for the price won when the case is won? Or if the funded party, third party, wishes to withdraw from the arbitration, is it entitled to proceed with the arbitration against that decision? You know, ICSID is an arbitration center established under the Washington Agreement, and which enables disputes between foreign investors and the host states to be resolved through arbitration. And also in some countries such as the United Kingdom, USA, Australia, Singapore, Hong Kong, and Canada, it is common for the arbitration to be financed by the third party. So, for example, the Association of Litigation Funders in England deals with the third-party finance of the justice, third-party finance. And also in America, you know, just Finance for the Justice platform. Yes, I'm right. Finance for the Justice platform also deals with the third-party finance. There are many different platforms in all over the world which are engaged with the third-party finance models. So, for example, we can say Singapore changed the provisions preventing third-party financing for arbitration cases in 2017. And again, in Hong Kong and Australia, we see that third-party financing is in compliance with the legislation. So the place of the arbitration in determining the rights of the financiers is, and the legislation that determines the arbitration is really, really important, and it is worth examining carefully for ourselves before the application, I think. And also in USA, some courts consider the financier as a party to the case if the financier has participated in certain stages of the case. So, as a summary, we can say that it is possible for the third-party financing. Haven't been started yet, but there are different practices in different countries, and also third-party financing exists a concept in arbitration really huge. Thank you so much.
Thank you, Begum. Can I have the next slide, please? Really helpful to have an understanding, and there of the risks of funding you need to take into account. And just thinking ahead, if that's something you're going to consider, which jurisdiction are you working under? Next, very lucky to have Karen Goff from 39 Essex. Karen is a renowned speaker and also qualified in a number of other jurisdictions. I think, I'm going to get it wrong. Jamaica, yes, and there's another one, I'm trying to think which it is. Oh, can't remember. No, Gordon's not helping me out. No, I can't remember. So where else you qualified, Karen?
Trinidad and Tobago.
Trinidad and Tobago. There you go. How can I forget? Well, Karen, over to you for your question. Next slide, please, Catherine. Thank you.
Right, okay. This is my question. Are there any material differences between the dispute resolution provisions, and particularly where statutory adjudication under the Housing Grants Construction and Regeneration Act is concerned, between NEC4's dispute resolution services and the new JCT DAB documentation 2021? And the answer is yes. I could stop there, but perhaps I should just briefly explain. I'll try and be brief. Robert Gerrard is rubbing his hands at this moment. You appreciate this, don't you? Because the JCT provisions are new, obviously. I say new, they came out in late May. The NEC4 dispute resolution services contract, which has been around for a while now, has 3 different dispute resolution mechanisms, and they're distinct. W1 is where statutory adjudication is not applicable and the parties choose adjudication. W2 provides for statutory adjudication under the Act, quite separate regime. W3, again, different regime, new option just for NEC4. It provides for the appointment of a dispute avoidance and adjudication board, I think. But anyway, there's no overlap at all between those 3 procedures. So obviously, I won't go into the adjudication provisions. We all know a party to a construction contract in England has a right to go to adjudication at any time. So the JCT, in particular for its 2016 design and build form and the major projects forms, decided that it wanted to introduce provisions whereby it could actually get onto the dispute avoidance and adjudication board bandwagon, similar to FIDIC and NEC4, and come up with a mechanism that was also compliant with the statutory adjudication regime. So it produced its JCT DAB documentation in May 2021. And the reason I even thought about this, actually, I should just say, is that Sean Gibbs from the UKA adjudicators, he had a discussion forum in early June about it, and it actually prompted me to look at all 3 systems to see at the ways in which they were different. And the thing about the JCT regime is it's different. Hats off to them because it's innovative, but there are a couple of big question marks about it, because it has produced a single process which is intended to cover all the shades of adjudication, including statutory adjudication. What it's done is taken the Chartered Institute's DAB documents, DAB rules, and adapted them. And it's come up with its own rules. I commend you to look at them, but the 3 things to look out for with the JCT rules is you appoint once. So you have 1 or 3 adjudicators. And of course, if it's a statutory adjudication and you have a 3 adjudicator panel, is that going to be compliant? Is that going to be at risk of challenge in front of the courts? Because you end up with 3 adjudicators. Now, if you have a unanimous decision, you might be all right. But if you have a majority decision, or if 2 don't agree, you have the chairman's decision. What then is the risk of that decision being held invalid under the statutory scheme? The other thing which the rules had to grapple with is where you have in the advisory avoidance function a kind of shuttle diplomacy. How would that deal with the risk of a Glencock Developments issue, where when there was a mediator who conducted shuttle diplomacy, he then got, the court then refused to enforce his award as adjudicator later because they said there was an obvious risk of bias. So what the JCT has done is said that there'll be no diplomacy where one party is in the room. There'll be no correspondence just with the adjudicators and one party. So they've tried to cover that off, but obviously there's a risk with that as well. So although I think it's a great idea, I think if you're advising right now, certainly my advice to a client would be sit it out until there have been 1 or 2 decisions on it, because you couldn't be sure that if you went down the road, that actually you wouldn't be the person that was in front of the TCC trying to justify whether a 3-person panel constituted an adjudicator under the Act. So they're different, and there are some risks with these new rules, but it's a bit of a suck it and see situation.
Thanks, Karen. And once again, it shows that even the great and the mighty don't necessarily draft things that the rest of the construction industry can instantly accept and agree to interpretation. And you're quite right that it's likely that there are going to be some bumps along the road before the JCT procedure is probably fully adopted, or perhaps even it might be subject to further change. And hats off to NEC for maintaining its ability for its very clear language and plain English approach. So hopefully people have now got something else to think about, even under areas of their contract where they perhaps thought, before you were speaking, Karen, that they were fairly simple. All they had to choose was between W1, 2 and 3. And now they realise that it's actually not that simple at all.
Bill, could I just say that I actually wrote an article which was published in, I think it was Construction News, but it's available free on Chambers Construction and Commercial blog, which actually dealt with the whole NEC, FIDIC and JCT documents. So if somebody wants to really get into it, that's a good starting point. Okay, well, we'll try and put a link to that, Karen, in the email we send out tomorrow, so that people can go straight to 39 and find that article. Yes. Fantastic. Our next speaker is Roger Tahar, QC, from Crown Office Chambers, fabulous chambers of the late David Sears. Roger has practiced as a barrister, adjudicator, arbitrator, and now also sits as a Deputy High Court Judge in the TCC Court. Roger, can we have the next slide, please? If you'd like to read and give your question and answer, thank you.
Thank you, Bill. Well, the question, should discussions between opposing parties' experts in arbitration and litigation cease to be held on a without prejudice basis? And my answer is yes, this practice should stop, because the practice is open to abuse by instructing lawyers, particularly in international arbitration, where those lawyers may not have experience of this process, and I may say may not have experience of what without prejudice means. And I say it's unnecessary if the experts act in accordance with usually expected professional ethics to cloak the discussions by holding them on a without prejudice basis. Query, should practice, which have grown up over the last 20, 30 years, be rethought?
So, Roger, you would see this from the very outset, that there would be no, without WP sort of element to any discussion between experts at all?
I think, yes, it's a balance to be struck, but I think from what I see both as counsel and as arbitrator, there's an awful lot that goes on behind the scenes, which causes quite considerable friction in some cases. And I can't see any reason why reputable experts can't conduct these discussions, perhaps by keeping a record of what's being discussed, and if necessary, that can be shown to the parties.
No, I don't actually. Perhaps it's unusual. I don't actually disagree with what you said. I think that experts, a lot of that is, to me, is down. I'm interested by if people have different views in chat. A lot of this seems to me to be down to how good the instructions are to experts at the initial phase. And it's my experience that sometimes these situations arise because experts have not been properly and fully instructed, and therefore they are very cagey about the way in which they will engage with other people, because to a degree they're fishing for information that perhaps they haven't been given by their client. And so I do wonder sometimes if that without the element is, using your term, a cloak of used as cover, whilst they're really trying to work out, you know, what their position will be as an expert. So I don't know if that's accords with other people's views.
Maybe if you could have it in a phased way.
Yeah, but even really from there's a lot of movement now. There's lots of discussion, isn't there, between should the extent to which parties, you know, have the ability to control their experts. There's new rules on witness statements, for example, and there's a greater push by the courts for us solicitors to have less involvement with the rewriting of experts' reports, which has been endemic over years, and to effectively go back to an earlier period where they were truly written by the expert, with very little lawyer touch, a lighter touch of lawyers, and that might well then encourage parties not to hide behind WP discussions. Well, thank you very much, Roger. I think that's it's a very interesting question, because I think that's one of the moment I sat on an SCL talk this morning between SCL in England and Australia, and one of the subjects that came up was the question of whether parties should still be able to have their own expert, or whether in more matters it should be a court appointed expert. And the overwhelming response to that survey was that parties to international arbitrations didn't want their experts to be court appointed. So it shows that the parties are very keen to keep control of their experts. I think that in turn leads on to that sort of WP element as well. So yeah, Karen says, worries that in those circumstances, parties will shackle. I want to read the whole thing. Shackle their experts even more. Well, that is the problem, but I think that's the balance between, are you as a solicitor and a party, are you instructing an expert purely because you think and expect that you will, in broad terms, give them a report and ask them to present that to the tribunal? Or are you actually instructing an expert because you believe that he is an expert in their field, and they are going to review your case, good or bad, and you are going to get an expert opinion on your case? It should surely be the latter, but I know that the former is far too common. So, okay, well, thank you, Roger. If we move on now, I know that Chris Evatt is here and he's the next speaker, but just to be difficult, Chris, Len Bunton has to go. I know he has other timetabling issues. So, Len, can you turn your camera on? And if, Catherine, we can skip through Chris to Len, and then we'll come back to Chris afterwards. I know you're just dying to go there, Chris, but Len, are you there? He can't have gone.
Len's logged off, I'm afraid.
Oh, okay. Len had to go. So I thought he had to go at 12. So I was trying to get to him. So we'll go back to Chris. So Chris Evatt, Director at CCI. They are specialists in quantum, and he's done a lot of international work. So Chris, what's your question?
Thank you, Bill. Yeah, my question is on provisional sums. So the question is, if a provisional sum is defined but not instructed under the contract, can an employer procure a third party to complete that work? So just to put this question into some context, I still get quite a lot of disputes around provisional sums, the implementation of them and also the valuing of them. And to flip it on its head, quite often contractors will undertake provisional sum work without an instruction and then struggle to get paid for that work. So that begs the question, does it form part of the contract or does it not? So my answer is, it depends on the timing of the provisional sum and when the work in determining the answer. So, for instance, if the project is still live, the provisional sum forms part of the contract, but it still needs instructing. And until instructed, the contractor can't deliver it, in theory. And it therefore cannot be awarded to a third party. That would be a breach in such cases. After completion of the works, as with any scope really, if it's not completed under the contract, then the employer is entitled to bring in a third party to complete that work. So, a case of it depends on the timing of it, but provisional sums are still a quirk of contracts, to be honest, where scope isn't yet determined and fully defined. So that's my answer. From experience, it's still a live issue that crops up many a time.
And I suspect will crop up even more, do you think, Chris? Do you think provisional sums are more prevalent now in contracts?
I'm seeing more of them. Certainly in JCT, I've seen people try to introduce them into NEC, which doesn't lend itself to provisional sums, and less defined as well. So yeah, I don't see this issue going away.
And why? Sorry, why do you think they are poorly defined?
A lot of the time, it's employers trying to push the risk onto the contractor or not fully undertaking its design obligations prior to contract, rushing into contract, trying to get work and projects off the ground, which is specifically what provisional sums can be for. But in the past, they've always generally been associated with things like statutory undertakers and services, stats outside of the employer's control. What I am seeing is employers using it to cover their own scope that should really be defined at the time of contract and just not being ready themselves.
Robert Gerard, I'll read his comment in a second. So Chris, what's your advice to contractors then? Because I do see an increasing use of provisional sums. What would be your advice to a contractor presented with a number of provisional sums?
Well, there's a couple of categories. Sometimes they're presented and the employer prices them and puts a sum in the contract. In some other cases, the employer asks the contractor to include a provisional sum in their tender, which is a little bit odd, because actually the remedy of how you value a provisional sum doesn't change regardless of who put that sum in there. So I would advise a contractor, ensure that even if it's not defined and therefore in the programme, at least put a milestone in your programme to know when you need clarity on that provisional sum, because otherwise, it will impact your works if it's not instructed. And when it is instructed, you need to be ready to determine what the impact of it is. And also, it will come under the same scrutiny as a variation or a compensation event under the contract. So make sure that it's valued in accordance with the provisions.
Okay, and I think that's very good and clear advice. And just so everyone has attention is drawn to it, Robert Gerard has said that they're not part of NEC, which they're obviously not. And if you don't know what you want, keep such risk as a client risk on their project risk register. I mean, the simple point is, if you don't know what you want, then you have to question why someone's starting work. I know there are occasions when you do so, but it's about the definition of work, and certainly as a contractor, not taking on elements that you really do not know what the outcome will be. Okay, next. Thanks, Chris. That's
Thank you.
really helpful. I hope everyone found that useful. I'm not sure if Len will be able to make it back, so I will. Len Bunton is very well known adjudicator, surveyor, quantity surveyor. So Len's question is there growing support for the RICS conflict avoidance process? And his answer is yes, of course it would be. Resolve disputes at an earlier stage before they become dispute. He's a member of the RICS Conflict Avoidance Coalition Steering Group, and it's clear that claims and disputes are viewed as an integral part of the construction process. So that group was formed as a result of that, and they accept that there may be extensions of times, variations, Chris just mentioned, failure to serve notices or defects, and those can be resolved through the contract mechanism. What the RICS has initiated is a way in which to resolve these at an earlier stage rather than waiting. So the conflict avoidance requires clear, concise, careful and proper planning of the strategy for the execution of a project. It's about adopting a positive conflict avoidance approach. Now, obviously you'll get these slides tomorrow and you'll be able to download and get the link there to the RICS conflict avoidance. So the CAP working group in Scotland, of which Len is a member, includes public and private sector procuring authorities, construction organisations, design teams, and they now have a number of projects proceeding with CAP, forming an integral part. Cross-industry support is excellent, and with the Scottish Government, and I'm pleased to say that I've been invited to attend one of the next meetings of the steering group to speak to them from another perspective. I think it's a really good initiative by RICS. I do recommend that you all look at that guidance, because disputes will arise, but the more you can plan for if those happen and how you're going to deal with it, the greater control you will have and the greater understanding of both parties. And it's about, again, collaboration. It's about looking into the future and thinking about what problems may occur during the course of the works, what things may you encounter that will impact upon the time and cost of your project. And if you can think about those in advance, it may be that some can't be avoided, but those ones that can, you can definitely narrow the risk. So we move on to the next slide, please. I would tell you we're just over halfway. We've got a couple of, we've got a great question from Donald who's here, and then we've got closing questions from Nick Dennis and Paul Darling. So don't go away. Jamie Gray is founding partner of MPG Baglos, and is also one of the leading people within the International Construction Projects Group within the International Bar Association. He's carried out a wide variety of very substantial projects. And Jamie's question relates to the impact of COVID-19 on liquidated damages within established forms of contract. So as he says, for years, projects funded by institutions, the World Bank and the rest, use an EPC type contract. And that was for the certainty of price and with the aim of transferring as much risk as possible to contractors. Contractors obviously charged a premium to cover what they saw as that unfair division. So it may go back to the point made earlier about ground conditions. So you're basically saying to contractor, I'm paying you, you're going to take the risk for everything. So recently owners are considering how to avoid payment of large risk premiums. So that is where, if anyone is misunderstanding, on a large project, a contractor looks at that project and says, well, I think that's going to cost me 50 million to build that. But then they look and say, well, there are going to be risks with ground and there's going to be some other risks. Or I'll tell you what, let's put in a 5 or 10% or a bit more figure on top. So they add 10%. So suddenly there's another £5 million, and that's just risk. That's not, sometimes it's allocated, but sometimes that's sort of the risk premium. So owners are wanting to reduce costs down. So they want to reach certainty of price, and that requires a collaborative approach. So that's a two-stage. So pre-construction, that means collaboration between the parties, establish objectives and key performance indicators to avoid the high risk premium, exchanging information, execution of early works. I'll come back to this. And then the construction phase, which would normally be some form of design build, but it might be design build operate. So it's a turnkey lump sum contract, target price or guaranteed maximum price. But bear in mind, a guaranteed maximum price is only guaranteeing the maximum price that you're agreeing, and it's then subject to the wording, have you actually allowed any possible variation of price or work? And as he says, this requires more investment in time and money, but it will change only if there's a change in the participants' behaviour. So looking at number one, pre-construction, back to my earlier point. If you have information as to ground or perhaps access to site or any other factors, then recently I looked at a matter where it was the division use of the site by other producers and then security, and that information could and should have been shared with the contractor but wasn't, and the owner in that instance left it to the contractor to find out and discover those problems, and of course that caused delay and their contractor's claims. And okay, so there's now going to be a dispute, but also that could have been avoided and the very significant delays had there been a greater degree of openness and collaboration between the parties at the outset. And yes, it does take a little bit more time and money, but it's a lot less expensive than litigation. And so I would echo Jamie's comment, and I'd encourage all of you, and this isn't any form of sales pitch, but you do need to look at your forms of contract. You do need to engage and get really good quality advice to understand both the risk that you are giving to a party, and if you're the recipient, what is the actual risk you're taking. Next slide, please. So Chris, based in Las Vegas, was going to get up this morning, but it would have been 3 o'clock, but he had a late night in the office, so he messaged me and said he's not going to be here. Next slide, please. Chris has actually given us 2 questions, which are similar but slightly different. So the first is the use of Teams or Zoom effective for mediation? And excuse me, this touches on a number of issues. So he said mediation style. So the point he's making here is, if you're at home, you're subject to a number of distractions, but you're not kept away from your home. One of the benefits of mediation in a remote location is you want to get out. You want to get out from that mediation centre or from that office. You want to be released. You want to go back. And that drives, towards the end of a mediation, a willingness of compromise. It encourages movement by the parties. The other one he raises is it's hard to see people's reactions when presenting, and that's certainly true. Body language has certainly changed. I know that years ago, body language was hands and your general demeanour, but more often than not, nowadays, it's just this bit. All you see is the face, and you can't see any movement of hands or that general body language, and that does mean that you're restricted in some of the information. So if you haven't been doing it, you need to start thinking about what is the new body language that you're seeing from Zoom calls. And there's a lot of things. We had a trial where you could definitely see where a witness was going to lie, because basically every time they were about to lie, they had a little sip of water because their mouth was going dry. So, and lastly, the ability to make a deal, relationships. Frequently in mediations, it comes down to bringing parties together. You've had a long day and you bring the opponents into a room and they have that one-to-one, and they will compromise. Next slide, please. But what are the advantages in relation to effective testimony? Well, again, it depends on which side of the table you sit. So advantages, and I think these are great. There's no travel, there's reduced costs, there's more prep time, more access to documents. That one, there is a difference. In America, you can bring documents to depositions. In English trials, you can't bring new documents to a trial. So we had a virtual trial last year, during which time we're cross-examining a witness, and he produced an entirely new file of documents, and that's a bit of a no-no. So it does depend where you are. Disadvantages, as we've mentioned, body language, you have technology breakdowns, you have interruptions, there are distractions from families, perhaps dogs, children, whatever it is, going past, and a lower ability to monitor the person being questioned. I'd also add into the disadvantages that, and it's a very good example of a flip side, a hearing where you've got parties in multiple locations, where you would normally bring them to a central location, but you decide to go ahead with the hearing virtually. But perhaps you've got people in England, America, perhaps in the United Arab Emirates, perhaps in Bulgaria. So everybody's in multiple time zones. So you may have some people, and then you've got the tribunal, who might be in South America. So you may have people across so many time zones that some people are working at night. And therefore you're getting a disadvantage for some people, but an advantage for others because it might be their normal day. So there are a number of things you have to consider. One of the big advantages that hasn't listed there actually is just the fact that you can get on. Having virtual hearings, certainly in England, has enabled us to progress matters with interlocutory hearings. We've had mediations, we've had trials as well. And it's not a one case fits all. I think with really good preparation, we're incredibly lucky. We use virtual approval for all ours, and they know what they're doing. And we've persuaded courts to use Zoom, which isn't their accepted method, it's normally Teams. But I would say to you all, however you use virtual technology, preparation, there is just nothing that will match up to the amount of preparation you can put in your witnesses and experts to make sure that people have connections, they have documentation. If you're using an electronic bundle, no amount of practice is too much, I assure you. And be prepared for things to go wrong. So you're working electronically, but remember, if that goes down, will you have a hard copy bundle? And also think about where the parties are, the backdrop, lighting, sound, a little investment in better computers, perhaps for your main witnesses or experts, is a tiny expense for your client that might derive huge benefits. Can we have the next slide, please? Next, Donald, I know you're there, fantastic. You're muted, excellent. So Donald should, of course, need no introduction. But I'd introduce because Donald is probably the person who knows more about FIDIC than anybody else I know. He's written some amazing books. Donald is an incredible person. If any of you ever have the chance, I thoroughly recommend invite Donald out for dinner. It will be some of the best money you've ever spent, apart from on his books. So Donald, would you like to introduce your question?
Yeah. Thanks, Bill. Well, my question is, will building information modelling make a substantial contribution to more successful construction projects? And there are two answers to this. If I wear my engineer's hat, remembering that engineers are eternal optimists, the answer is obviously yes. BIM can substantially improve time, cost, and quality outcomes, because you've got the ability to share up-to-date documents in real time. That can lead to significant reductions in the time to prepare tender designs, provide more timely response to requests for information. Suppliers' access to detailed drawings will reduce procurement time. the design team can work off a common set of drawings, and you can identify clashes at the design stage. So you can significantly improve the quality of the design and avoid rework in the field, and those things should lead to a lower overall cost of the project. Wearing my lawyer's hat, of course, lawyers always have two hands. So the answer from a lawyer is that it depends. And it seems to me that if we stick with the current silo approach to design, procurement, construction, where every individual involved, every organisation involved has to protect their own legal rights, IP and so forth, there's not really going to be a lot of financial incentive for all the investment that will be required in hardware, software and training. And if we don't make that investment, then we're not going to get the potential benefits that can be achieved from BIM. But on the other hand, if we have a bit of a paradigm shift in the way we procure, design and construction, focus on the value added rather than the cost, then we can achieve the benefits of BIM by a more collaborative approach. We need to fully address the proper management of the BIM model throughout its life, the IP issues, the investment costs, and a rational allocation of the risks. And this will require significant investment at the front end, but will result in substantial savings over the life cycle of a project. Now, whilst the question was about a more successful construction project, perhaps the greatest benefit ultimately of BIM is going to be in those life cycle costs, which ultimately are substantially more than the first up construction costs. But it does require, as I've indicated there, really a paradigm shift to move to a more collaborative contracting model where we don't have every individual entity having to worry about their own legal liabilities for mistakes and so forth. So that's my question and answer.
Thanks, Don. And I wholeheartedly agree with you, actually. I think there's too much short term rather than long term. I worked on a very large office project in the north of England a couple of years ago, and the problem was that BIM wasn't used, and it was just viewed as too expensive in that short term, you know, in the sort of the build. And I raised at the time, but surely this is a big building. It's going to be owned by an investment, you know, retirement fund or whatever. But it was the immediate cost. They sort of refused to look at that longer term benefit. I don't know about in other countries, but I would say that certainly the pickup of BIM in the UK is much greater in London than you will see outside London. And that's primarily because the value of the buildings is significantly greater, and therefore the element of BIM cost is a smaller proportion of that initial build. And I think therefore people are more prepared to see the longer term benefits. I think certainly as you sort of, the value drops, people take a much more short term view. And I think that is a shame. I don't know if anyone's experience who's listening is different from that, but we could certainly make more use of BIM everywhere. Brilliant, thanks Donald. Next slide please. Next is Carol Ann Watson. So she's particular expertise in public sector projects, in, as it says here, housing, heritage, sports and leisure, with contracts valued up to about 40 million. Next slide please. And Carol Ann's question is about material cost increases. So a further implication of the long lead times for construction materials is that they are increasing in price. There's an unprecedented demand because of home owners. Obviously, everyone's been stuck at home, they saved money, and they're now doing DIY at home or extensions. There's an increase in larger scale construction work, major infrastructure projects, and also those projects that were just perhaps stalled or suspended during COVID are restarting. The situation's made worse by material shortages caused by reduced labour to produce materials. So, for example, wood production, Brexit and increased paperwork and delays on imports, huge shortages in HGV drivers, again, primarily caused by Brexit, but that's not just in construction. There was an article yesterday, I think it was the head of Tesco's, saying that they are a few hundred lorry drivers short and warning about Christmas shortages. Containers, shipping containers aren't in the right place. There was the problem with the sewage blockage. There's been a backlog of containers at Felixstowe, and there was the closure of the Ningbo Zhoushan port in China. We've also suffered from the pingdemic and now holiday backlogs. And so that's all was also shown, as I mentioned earlier, by the closure of British Steel, 2 new orders in April of this year, where they blamed high demand and their inability to produce or price. So Caroline's pointed out that steel rebar, that's increased by some 25% plus from July. Paint has gone up by 33%, and aggregates have increased by nearly 7%. That's in the UK. So in the chat, it'd be very interesting if any of you could put in information about the increase in prices of materials you've seen in the locations you're in. And let's think about some of the main materials, so perhaps steel, wood, or aggregates. So have you seen an increase in cost? And is that also an increase in the delay in obtaining materials as well? So if you can put any of that information in the chat, that would be very interesting to look and compare, and we can talk about at the end. Next slide, please. Next is Laura Chelliker from Fairhurst Design Group. So she looks at feasibility in design and management of projects. The next slide, please. So what are her top tips to communicate with clients about those material delays? So she says, if there are delays in supply, delivery or provision, one of the likely consequences is going to be that you're going to use new or alternative materials in order to keep the project moving. So it's really important to communicate this to the client at the earliest possible point and think about the consequences. So we're all sitting here thinking, well, that's blindingly obvious. And this is the point raised by one of our earliest speakers, I don't remember who it was now. But you have to think about the consequences of those new materials to the project documents you're working to. So are the new materials meeting the specification of the original contract? So it's all very well introducing a replacement that you say is like for like, but has that been approved by somebody? Because what you don't want to do is introduce something that you say and they accept is like for like, but then down the line, it turns out they'll turn around and say, well, that's not the specification. Are the client's requirements still going to be met in the original contract, whatever those are? And what about fire safety? That can be a big issue, particularly if the material you're introducing is new and perhaps it hasn't had the necessary accreditation. Do the materials work or fit with other materials from a technical point of view? And again, obviously not something as a lawyer I could ever answer, but have you thought of that in terms of their maintenance, sustainability and the like? And do they comply with the contractual requirements as to deleterious materials? So obviously they cannot be deleterious materials, but you need to go back and look at that definition and look at what you're planning to introduce. Next question, please. She's also said that it's most important to allow time for this process. So this is going to take you time, and what you don't want to do is get into a delay situation. Therefore, it's really important that you start thinking about giving notices, and as was mentioned earlier, keep a really good record of that conversation that you're having with the other side. Next question, please. Alan Booth is an architect based in the north of England. Next question, please. Alan's question is, okay. You are contract administrator for a project which is on site. A subcontractor calls you to say the main contractor's gone bust, trades are leaving, what should you be doing? So his advice is check, correct and make arrangements about site security, because it's amazing how quickly goods will leave site, and particularly if your client has already paid for them. Inform the client and inform the insurers, because the insurance was probably held by the contractor and you need to move it back to the employer. Then other tasks include site inspection, engaging others to complete the work, so that may require retendering, and assuming arrangements for completion, you may need to liaise with an insolvency practitioner. I'd add to that my strong advice to take very detailed photographic evidence. I would suggest that you always video a site. You should have a record of what materials are there and where are they, the current state of the work on all parts of the building, and a detailed inspection as to whether there are defects in the building and where and what those are, or are there works that are incomplete, and will it be possible to complete, say, off the top of my head, a boiler? Is it possible to complete that work by another contractor and still have the necessary warranties? Next question, please. So, Nick Dennis, QC, Akin Chambers. Nick acts as an arbitrator, adjudicator, and mediator. He's also acted as a party-nominated arbitrator, chairman, and sole arbitrator on many occasions. He's ranked as one of the leading QCs in the world. Next slide, please. And Nick's question is the concept of fiduciary duty useful in defining the relationship between an expert witness and his or her client? And he says, not in my view. Whilst it's obvious that an expert should not advise two clients with different interests, the reason is not that the expert is a fiduciary in the conventional sense, but rather that the expert could not properly fulfill his obligation to both clients and the tribunal, trying to serve two masters. So what he's doing there is distinguishing between a duty, an obligation that arises because of being paid, and the pressure and obligations that arise from that. And your duty both to a client and a tribunal when you're acting in the role as expert. But obviously between the expert and the tribunal, there's no exchange of money or anything else, but you owe certain obligations. Next question, please. Lastly, and then after this, we'll go back to Len, so you can tell you a bit more about CAP. Len's back. Paul Darling, OBE QC from 3906 Chambers. I've been very lucky in the last year to have Paul on a matter that went to a virtual trial, and there probably isn't a better trial lawyer in the world than Paul. His cross-examination of witnesses and experts was amazing. Next slide, please. Paul's question is, how can you win 6-3 and lose? Well, this is all about the English court system. So he's talking about the case of Triple Point, where Triple Point succeeded in persuading at first instance Judge Jefford and then the Court of Appeal that the reference to negligence as an exclusion from a limitation of liability applied only to the tort of negligence, not a contractual duty to exercise skill and care. In the Supreme Court, two of the further judges agreed, but unfortunately, the other judges in the Supreme Court disagreed. So you had a position where, as he said, 6 judges on the way up all agreed with Triple Point, but they lost their case. And that shows you the risks of litigation in England and Wales, that because of the tiered system that operates, it is not necessarily the case that when you win at first instance, that will be maintained all the way through. So those are all the questions. I know that Len's come back online, Len, if you can turn your camera on, it'd be great, Len, if you could just very briefly, because I know we're running quite late, tell people about the conflict avoidance procedure that RICS has set up and your engagement with it. And then, Catherine, if you can put it on to the next slide. No, well, yeah, if you go back to Len's slide, that'd be good. Thanks. There you go.
Okay, thanks, Bill. Apologies, I had to dive off to deal with a problem a client had. I don't know how much, to what extent Bill has touched on my slides, but I think the RICS conflict avoidance process is one of the most important matters that's happened in the construction industry for a very long time. And I think now there's a realization from the industry that early intervention into the resolution of contentious issues on a project as they emerge is going to be a very important factor. And there's or working with various working groups, there's tremendous enthusiasm for this process. It's perhaps worth mentioning that the background to all of this is some work that the RICS carried out with Transport for London over the last 3 to 4 years, where they piloted a number of schemes. The RICS brought in a sort of panel of different individuals with high-level industry experience, and they were brought in to resolve issues that were emerging in prospects. And the proof of the pudding is that the outcome was that TfL reduced greatly the amount of money they had to spend on settling contractual claims, and also there was a significant reduction in legal costs. So that has to be attractive to the whole construction industry and to procuring authorities. And the ethos of somebody coming in at the early stages to deal with issues, these could cover a whole range of subjects. The ones that I've seen deal with design responsibility, design issues, and what is actually design development, which is an unanswered question that the industry has had to face for many years. So it's a case really of getting people in the room, adopting a flexible approach, finding out from both sides what the issues are, how they see the issues, and what do the parties want to do to resolve this. If you could go on to my next slide, Bill, please. Again, I'm involved in a working group. I'd like to refer to it as the northern part of the United Kingdom rather than Scotland, but we have a very active working group that has been set up that is cross-industry. It involves a number of public and private sector procuring authorities, government departments, it involves the tier 1 contractors, it involves design teams and the professional institutions, and most importantly, it involves the supply chain, the SMEs who are actually responsible for most of the construction work in the United Kingdom. Because this process can only be successful if it gravitates right down the supply chain to resolve issues that they have up the line with the main contractor. We've also had significant support from the Scottish Government. They are supporting a collaborative approach to procurement. And as an example, recently, the Scottish Government have recommended that the conflict avoidance process be used to resolve emerging issues to do with material price increases and delays to construction projects, which other speakers have mentioned. So what are the key benefits? Well, in my experience, it's flexibility. You don't go into a room with a rule book and say, right, chapter 1, I'm going to do X. You deal as flexibly as you can with the issues that the parties have. You use the conflict avoidance process when you have to. As I've said earlier, it's been a very, very cost effective. A lot of the issues that TfL have been dealt with, the fees of the CAP professionals have been remarkably low, and they've been able to get through these issues sometimes in 2 or 3 days and come back to the parties and say, here, I think there's a solution. It requires engagement and commitment. It also involves people actually meeting face to face or in forums like this and not hiding behind emails, which is endemic in the construction industry. One one of the most important things to me, Bill, is that it preserves relationships between the employer, the contractor, and the design team. Anybody who's been involved in an adjudication during the term of a contract knows that there's no recovery after that, after people examine submissions and look at criticisms that have been made. So all of that is put to one side. Now, I would to recommend that you all have a look at the RICS Conflict Avoidance Pledge. There are 260 organisations in the United Kingdom that have signed up so far. The target is to get to 500 at the end of the year. And these are organisations that are committed to engaging in cooperation and collaboration to resolve any of the problems that they have. So in summary, I think this is an incredibly exciting process. I think it will help the industry to go over the problems we've had over the last 18 years with COVID, 18 months, sorry, with COVID, and get back on its feet again. And you may have gathered from my talk that I'm a great enthusiast for this approach and would thoroughly recommend it. And Bill, thank you for the opportunity of speaking at your excellent seminar. Thank you.
Well, thank you very much. And again, I would thoroughly recommend everybody looks at the guidance. We've put a link on there for everybody to see. Catherine, if you just go to the very end slide where it refers to the next webinar. I'm really grateful to you all for attending today. And if I can just remind you that our next webinar is on the 23rd of September at 11 AM, where I'm really fortunate to have Marion Smith, QC from 39 Essex Chambers, and Robert Gerard from Thomas Telford, who will be speaking. If any of you have any questions, then please, you'll all get an email tomorrow. Do not hesitate to send me an email asking questions. As I've said to everybody before as well, if there's anybody that you've seen their name when you've been looking through the attendees that you'd like to be put in touch with, I'm quite happy to facilitate that if I can. I'm not possessive in any way. If you want to speak to one of the other solicitors, barristers, or whatever are on this call, then that's absolutely fine by me. I want everybody to spread the word. If you can tell other people, if all of you who are still on 50, if you can get someone else to come along in September when they're back from holiday, that would be great. The aim is to make these as collaborative as possible and to put information out there for your benefit. So if there are questions or things that you would like, then please do email me. The purpose of these webinars, as I say, is really very much to share with the industry as a whole. We've had people from over 41 countries on today, and I think that demonstrates the benefit and the importance and the need to share information with our colleagues in other countries where we can learn from your experience. So that's why it's so important. Thank you all again. I'm especially grateful to all of my speakers today who've attended and those who weren't able to attend for providing questions. And that's it. In the words of Cilla Black, ta-ra.